Okay, good morning, everybody. Welcome. This is our inaugural podcast for the Pie Shop. This cast will be sponsored by the Pie Shop, of course, and it will also be sponsored by Blue Dolphin Design and Engineering. I'm really glad to be doing this first podcast. It's going to be the first of many. We're going to continue to do this, and you guys will hear about this when we're doing it. And the subject of this first one is intellectual property. And for those of you who don't know what intellectual property is, hopefully you'll learn some things today. And what intellectual property is is patents, trademarks, copyrights, those kind of things, and which most people have heard about. And so today we have a really wonderful guest, Sherry Flynn. She graduated from Carnegie Mellon University, got a bachelor's degree in mechanical engineering, and then she got her Juris Doctorate in law at San Joaquin College of Law here in California. She currently is an attorney and a partner for Coleman and Horowitz, and she represents clients in intellectual property registration and enforcement, including patents, trademarks and copyrights, business and business torts, and construction. And she has over 30 years of business and engineering experience. And anyways, welcome. Good morning.
Good morning, Mark.
Thanks for coming in. I appreciate it.
Thank you for having me. I really appreciate it.
Yeah.
You had to mention that 30 years, though.
Well, you started when you were young, I'm sure.
I was a baby when I started.
You were a prodigy, probably. Yes.
Uh-huh.
So let's just kind of start this. I think some people have some idea of what the things are, the patents are, and those kind of things. Can you elaborate more on what a patent actually is?
Absolutely. A patent is a right granted by the government, by a U.S. government or a foreign government, but, let's talk U.S. patents. So it's a right granted by the government that gives you the right to exclude people from making and using your invention or selling your invention in the United States if it's a U.S. patent.
Okay, so what type of things can you patent? I mean, can I patent a formula, or can I patent a machine? I would think I could patent, but what are the things you can patent?
Yeah, you absolutely can patent a machine. Mm-hmm. You can also patent a process or a method of doing something. You can patent a composition of matter. You mentioned a formula, composition of matter. So those are the basic things that are patentable.
So what kind of things can you think of that can't be patented?
There's quite a few things that can't be patented. And some of them might surprise people, but some basic things are you can't patent laws of nature.
Okay.
E equals MC squared is just not patentable. You can't patent mathematical formulations. I mentioned E equals MC squared, but even things like gravity, scientific, can't be patented. It's a law of nature. You can't patent heavenly bodies, things in space. You can't patent impossible things. I've had people come to me and they have some concept for a perpetual motion machine. And as you know, at least on this earth, you can't really have a perpetual motion machine, so that's not patentable. One thing people don't really realize is that you can't patent abstract ideas. If it's just an idea in your head, that's really not patentable. And lately, the courts have gotten to where they've really expanded on what is an abstract idea. So, for example, you can't patent something that can be done mentally or with pencil and paper and put it on a computer, and just putting it on the computer doesn't make it patentable. And games, for example, like the game of bingo, somebody tried to patent a computerized form of bingo, and just the fact that it was put on the computer did not make patentable.
Okay.
And the courts actually consider that an abstract idea, a method of organizing human behavior. So that's not patentable either.
Yeah, I know that Blue Dolphin, we definitely have had people come to us with ideas that we believe can't exist in the real world, this world, and or are perpetual motion machines. In fact, we've had people, I remember one individual came to me who wanted me to prove, he wanted to pay me to prove that what he was doing couldn't exist in this world. And I told him I could save him a lot of money and it'd take about 30 seconds and just say, no, you can't do that. So, but yes, so I kind of follow that, what can, some of that, what can be and what cannot be patented. Also, are there, if it's obvious to people in the industry that it's in other words, if it's an obvious step, doesn't that affect the patentability of something?
Absolutely, Mark. You're very right there. The things that I was talking about, like the laws of nature and the mathematical formulas, that's, that the first number one thing is to be patentable. Something's got to be patentable subject matter. So the things I was describing, the laws of nature, those types of things, abstract ideas, are not patentable subject matter. But as you were alluding to, in order to be patentable, it's also got to be novel. It's got to be new, something that's no one's doing right now. And it's got to be non-obvious. And the non-obvious concept's a little bit hard for people to understand sometimes. But if you're taking two different things and putting them together, and in the industry it would be obvious to combine those two things, then it's not patentable either.
That probably leads to some argument, though, right? It may not always be obvious that those things might go together. That's we definitely have, of course. Blue Dolphin has had instances of that same kind of thing, and we don't answer those questions. We send them to people like you. So.
Yeah, to the patent attorneys, and we argue with the patent office all the time with the examiners. We argue nicely, but we do argue with the patent examiners often about whether or not something's obvious in a particular field.
Oh, okay. So what are the, I know there's more than one type of patent. Can you go through the different types of patents and what differentiates those?
Sure, I'd be happy to do that. First of all, there's what's called a utility patent, and sometimes people use the term non-provisional and utility patent synonymously, but a utility patent protects the function of something. And I haven't really looked at the number, but by and large, the types of patents that are issued are utility patents. But there's also design patents, and there's also plant patents.
Oh, okay.
Plant patents is something that I haven't gotten into a whole lot, but I'll start with that and then work backwards because we can probably talk very little about plant patents. But plant patents, if you can produce a new strain of roses, for example, that could be patentable. It's got to be asexually reproduced, meaning that it can't be from seed. It's got to be like grafted, and it's got to be able to be reproduced over and over again and result with the same type of plant or the same plant. So strains of roses, for example, could, and other types of plants could be patentable. Most of the patents that I deal with are either design patents or utility patents. And design patents cover the ornamental look of something, not the function of it. So, for example, and you can get a design patent and a utility patent on the same thing. So, for example, I've got a client that does a lot of work in the electronics business, speakers, for example, and you can get a design patent on the ornamental look of something like a speaker. Or it could be anything, a jewelry box. If you've got some ornamentation that's really nice looking, you can get a design patent on that. A utility patent protects the function of something. So as I was mentioning, the client with the speakers, if they, for example, when surround sound first came out, that's pretty useful. That's a utility type of thing. The function of surround sound. is likely, I didn't check, but is likely patented for the function of that sound. So speakers could be patented for some new innovation, useful part of the speaker, and then also the look of the speaker.
Okay. So you mentioned the provisional patents. What is a provisional patent? That's kind of a newer thing, right? Or?
Well, it's not particularly new, but it's very misunderstood. In fact, you use the term...
I just misunderstood it.
Yeah, you just use the term provisional patent, and there's no such thing as a provisional patent.
Okay.
Okay, what there is a provisional patent application,
Gotcha.
which I think...
That's what it is.
Yeah, I know that's what you meant. But a provisional patent application is a way that you can get a patent application on file with less requirements from the patent office, cheaper, less expensive than a regular utility patent application. Now, a provisional is not available for design patents.
Okay.
But for utility patents, that's why I said utility patents could be called utility or non-provisional. But the provisional application allows you to get the application on file much quicker and easier because the requirements are less stringent from the patent office. And so you can get that filing date sooner, because you need the filing date as soon as you can get it. The problem with the provisional, if you want to call it a problem, is that they're not examined.
Okay.
In other words, you put a provisional patent application on file, the United States Patent and Trademark Office looks at it and says, okay, you've met the minimum requirements for a provisional application. They give you a patent pending application number, and then it sits. And nobody from the patent office examines it any further than that. But the good side is that you get a year. From the date you file the provisional application, you have 1 year to file a non-provisional application or a utility patent application.
Right.
And so in that year, you deal with a lot of entrepreneurs.
Yes.
I deal with a lot of entrepreneurs, individual inventors. And, oftentimes they've got the invention pretty well defined, but what they don't really have together is their business plan.
Sure.
How they're going to make it, how much they're going to sell it for,
Sure.
how they're going to market it, that sort of thing. So what the provisional patent application does is it gives them a year to kind of figure those things out before they have to go through the expense of filing a non-provisional application.
Right. So, what happens at the end of that year if they haven't filed the utility application?
If they haven't, then their non-provisional goes abandoned.
Okay.
And then they can't rely on that filing date after that 1 year period.
Okay.
Now, the provisionals are confidential. They don't get published.
Right.
So the idea, the concept, the invention is not published. So theoretically, at least, if they haven't made it, used it, disclosed it publicly, they could file again.
Sure.
But they lose the benefit of that early filing date.
Sure, right. So, there are a couple things I know that from Blue Dolphin's side that we run into related to patents in general. When somebody comes to us, occasionally they have their full utility patent application has been accepted. The patent has gone through and is granted, and so they're set by what they've patented. And sometimes when they bring us an idea at that level, and they ask us to develop it into the actual thing, the physical thing that they've patented, occasionally we have an issue where we're limited to work within the scope of what the patent says, and we can't work outside the scope of the patent because we could, in theory, develop a device that's not covered by the patent. And it can limit our ability to do effective work, to design and to add value to what they're trying to do. And so when we are working with a client who hasn't filed for the utility patent, it's a business decision, and in that it's useful for us to not be restricted by the full application or the full accepted patent yet, we can potentially add to it before it gets filed. Are there ways in that circumstance where somebody has a patent, they filed it, it's been granted, and there are things now that happen during the development that we want to add, that we want to augment that patent because of the actual development of the actual thing and prototype? Are there ways of adding those things to the patent after it's been granted?
You can't expand on the patent once it's granted. Mm-hmm. You can file another patent application, mm-hmm. and you can add to that patent application any significant improvements
right.
Over the initial patent.
Right.
So you can do that.
Mm-hmm.
Also, there's something called a continuation patent application. Mm-hmm. And if a patent is going to issue, but right before it issues, mm-hmm. you can file what's called a continuation patent application. And I often recommend the clients do that for a couple of reasons. Number one, if you have an open continuation, then you can make other claims. Mm-hmm. And the claims are really what you can keep people from making and using.
Right.
Or selling. Yes. So you want, as many claims and as broad as possible. So if you have a continuation application, then you can structure some additional claims to gain some additional protection. Mm. But the other thing you can do is you can file what's called a continuation in part application mm-hmm. before it issues. Mm-hmm. And it'll claim the priority date, the filing date okay. of the initial patent application, mm-hmm. but you can add material to it. Okay. Now, with the new material, you'll only get priority as of the date you filed for the new material. Mm-hmm. But that way you can continue to develop and expand on the patent. Right, right.
Okay, well, that's useful for us to know. As I said, to me, obtaining a patent, although as an engineer, I have patents in my name, and I have pride. I hang them on the wall. It's a wonderful thing. Uh-huh. But from a business standpoint, it's also a business decision because it's expensive to file for a patent. I mean, relatively speaking, could be expensive. And it's a long process. And you have to, I think you have to consider when you're filing for the patent, what is the life of your product? I mean, how long is it actually going to be produced? And are you going to make enough money to even to profit enough to pay for the patent? Or, what's your long-term goal? Are you going to produce this yourself, or are you going to sell your idea or license it to somebody else? So there's business decisions related to filing and why to file and I think when to file. Do you when you have clients, do they get advice on those different aspects of patents and when and if they should file? Or
well, to some degree, yes. I mean, I'm an attorney. I'm a patent attorney, so I give them legal advice. Right. Don't necessarily give them business advice per se. Yeah. On the other hand, there's certainly business considerations. Mm-hmm. You're mentioning when to file a patent, that sort of thing, mm-hmm.
Whether to file a patent.
Mm-hmm. That's all got to be taken into account. So I consult with them on things like, for example, terms of patent, how long a patent lasts. I mean, it's a right granted by the government, but for a limited period of time. So
what is that time?
Yeah, that time is 20 years from the earliest filing date.
Okay.
So when you file your non-provisional or utility patent application, mm-hmm. that starts the 20-year clock.
Okay.
With some, what I want to say, disclaimer to that, in the sense that if the patent office takes too long to examine your patent, mm-hmm. and it's their fault mm-hmm. that they're taking too long, then you can get an adjustment on that patent term.
Oh, interesting.
But it's basically 20 years from your filing date.
Mm-hmm.
And you're right, patents are expensive. Mm-hmm. Provisional patent applications are cheaper and easier to file. Mm-hmm. I'll throw out some numbers, and you got to take these numbers with a grain of salt.
Sure, yeah.
Because, some inventions are very simple, some are very complex.
Sure.
But when we talk about filing a provisional patent application, mm-hmm. we usually talk provisional in the $2,000 to $5,000 range to get the application on file.
Okay.
Okay. Now that application is not examined, as I said.
Sure, right.
So you spend $2,000 to $5,000 if you file the provisional first,
Right.
and you don't have to. But to get it on file, well, depending on your point of view, $2,000 to $5,000 isn't cheap.
No.
On the other hand, if you want to file a utility application to start with, we usually talk, gosh, if you can do it for $8,000, that's pretty darn good
Sure.
in my estimation. That's an application that probably doesn't have any drawings, like a chemical formulation, a compound formulation, usually doesn't have drawings. But, you're talking probably more like 12,000, 8 to 12, even could go as high as 15.
Sure, right.
Just to get the utility patent application on file.
Right.
So that's a chunk of change for people.
Sure.
So a lot of the inventors, single inventors, the entrepreneurs that don't have an established business yet, they'll file the provisional patent application, and then they'll take that year to determine whether or not to file the non-provisional, because it's going to cost, $10,000 or $15,000 to file that non-provisional.
Sure.
So that's all got to be taken into account. And then, it takes 3 to 5 years. I mean, you can do it quicker. You can pay to have it examined faster.
Yes, right.
But generally, it takes 3 to 5 years to get a patent.
Also, if you're a senior citizen, isn't there an expedited?
If your age can be, you can expedite based on age.
Okay.
Or if it's going to benefit the government, if there's some, new missile technology,
Yeah, sure.
that sort of thing, you can expedite based on that. Or if not, you can pay to expedite.
Right.
But, you've got to take into account how much it's going to cost, over what period you're going to pay. And I just mentioned the initial patent application being in that utility patent being in that, let's call it $10,000 to $15,000 range.
Sure.
Then, as you go back and forth with the patent office, which almost always happens,
Sure.
they always reject the patent to begin with. I've had like one in several hundred that got allowed on the first try.
Right.
Because they always, I think the examiners are paid to find problems.
Yeah.
Or they don't pay enough, they don't have enough time to really look at the other things out there.
Right.
So they just throw things out. So anyway, then you paid your attorney to argue back and forth with the patent office until you get a patent.
Sure.
So that costs money too. So
Sure.
usually you're talking at least $25,000
Right.
for an issued patent.
Right, over a few years.
Over 3 to 5 years to get it, and meanwhile,
Time is going by.
that time is going by. Yes. So all that's got to be considered.
So now, something I think that's newer, and I could be wrong about this also, is our maintenance fees. And tell us about the maintenance fees for a utility patent.
Basically, there's 3 times that you have to, during that 20-year period, that you have to pay fees to the patent office to maintain your patent. One is at the 3.5-year mark, one is at the 7.5-year mark, and one is at the 11.5-year mark. And the fees get progressively more expensive as you go on. And so it costs money to keep your patent in force, too. And if you don't pay the maintenance fees, then your patent goes abandoned and you lose the protection.
Right.
And a lot of people don't know that you have to pay those kind of fees. And depending on whether you're a micro entity, which is like a single inventor that
Yes.
doesn't make a lot of money, or a small entity, or a large entity, the fees are different.
Right.
Most of the people I deal with are either micro or small, although I do have large entity clients.
Okay.
But the fees are half as much for a small entity as they are for a large entity.
Gotcha.
So for a small entity, which is 500 employees or less, for a small entity, the fees on the 3.5-year are under $1,000.
Yeah.
But then they go, to 1,000 to 2,000 on the second, and more like 3 to 4 on the 11.5-year.
Interesting. Okay.
Yeah, and for large entities, it's even more. So you're paying quite a number of thousands of dollars to maintain too.
Okay. One of the things, I think one of the newer aspects of patents that's happened a few years ago was what's called first to file.
Yes.
Can you kind of address that and how the laws changed somewhat?
Yeah, sure. And the rest of the world was on this first to file system long before the U.S. and
Sure.
most of the rest of the world anyway. But it was March of 2013 that basically the U.S. put a law into effect that basically whoever files first has the first rights. It used to be whoever invented first. Okay, so what that means is if you and I both invent something, the same thing,
Sure.
completely separately, I don't know about you, you don't know about me, it's not
Yes.
like I'm stealing your invention, we just happen to do it simultaneously and separately. If I file first, I have the first rights.
Right.
Even if you invented before me,
Yes.
and I invent separately and
Right.
file first, I
Right.
have the first rights.
Right.
It used to be if you invented first and I invented second,
Right.
but I filed first, you could file and what was called swear behind me. You could show evidence that you
Right.
invented first.
So this is where the people would have a notebook or send a letter to themselves or
Right.
something like that, showing that they had a witness or somebody saying that they had actually invented the idea. Even though they didn't file it first, they actually invented it first. But now the law says somebody could have started the work the day before and filed the next day, and somebody could have been working on this idea for 10 years, and the person who filed first is the one who now gets priority, who gets
Correct.
That's an important.
That is an important
Because everybody always
distinction.
thought, I just, I have documentation, I have witnessing, and that used to be the way it was. It's not that way anymore. It's important to understand. It's a real significant difference for some people that you need to be careful about first to file. So, related to that, let's talk about public disclosure and how disclosing to the public affects your ability to patent something.
It does, and a lot of people don't realize this either, but if you publicly disclose your invention or you make it and sell it, you start a clock running. As soon as you make that public disclosure, as soon as you advertise for sale or sell the invention, the product, then you start a 1-year clock running. And you have to file for a patent in that 1 year, either provisional or non-provisional, but you have to file in that 1 year. If you don't file in that 1 year, you forever lose your rights to file a patent.
Forever lose the right.
Yes.
That's important to understand, because when you start talking to your friends or family or people in the public, and they have not been bound by some non-disclosure, correct?
Correct.
You could be jeopardizing the ability for you ever to patent your idea. And it's very important to understand that. It's not that you shouldn't be discussing it with the correct people, but for example, every person that comes to deal with Blue Dolphin on their ideas is definitely free to have us work with an NDA. We're more than happy to sign NDAs. We do it all the time. An NDA, by NDA I mean non-disclosure agreement. So it's important to have some of this in mind when you're going to start discussing your idea with people. Everybody gets excited. They want to talk to their family and friends. Just keep this in mind. It's important. At some point in time, I think early on in the process, you probably ought to just confer with a patent attorney and say, hey, what can I get away with? What should I do, before I actually file? Just to get the legal side of what you should or shouldn't be doing. So it's important to keep those things in mind.
Yeah, and I want to actually expand on that just a little, because a non-disclosure agreement is very important. I think what some people don't understand is when you file for a patent, what it does is it protects the invention.
Yes.
Okay. Oftentimes it's best, most of the time we recommend getting a patent application on file really before you start talking to people. But the non-disclosure agreement protects more than just the invention itself. It's a contract, and contracts can be broken, but the non-disclosure agreement can also protect your business concepts that aren't part of the invention. So, for example, how you might manufacture something, what you might charge for it, your cost of manufacture, who your potential customers might be,
Sure.
who your vendors are, all that confidential business information can be protected by a non-disclosure agreement, whereas it's not protected by the actual patent application.
Sure, right.
So we usually recommend that people do both. Get the patent application on file as quickly as possible, but have a non-disclosure agreement and have anyone, and I say anyone because, relatives you can have your brother that's just not a nice person, and he might try to steal your idea, your invention. So I say anybody that is not your attorney, you should have sign a non-disclosure agreement. So we recommend that, people dealing with you file a or sign a non-disclure agreement with you.
Good advice. Excellent advice. So, okay, so let's switch gears here a little bit. Let's talk about trademarks.
Trademarks are fun. I think they're fun. Patents are fun too because, from my perspective, I get to learn about the new technology with patents. But trademarks are a lot easier than patents. They're a lot easier and less expensive to get a trademark registered than to get an issued patent. But trademarks, people misunderstand sometimes, but trademarks are really words, images. They could even be sounds or smells.
Oh, interesting.
They can be colors even that basically identify the source of a good or service. So, for example, I mentioned sounds. Most people know the NBC chimes.
Yes.
Those are trademarks.
Oh, interesting. Okay.
Because anybody that hears that sound basically relates it to NBC. Most people trademark words or a logo, for example.
Sure.
But what that is it basically identifies the source, you as the source of your goods or services.
Yes, you recently trademarked the Pie Shop logo.
Yes.
Which sounds like we're going to trademark a new logo because it sounds like we're going to change the branding so much. So I'll have to talk to you about that. But anyways, so yes, okay. So for example, logos and things that can be identified to anybody, an organization, whatever. It's interesting. Smells. I didn't know that. That's
smells like a perfume smell or something.
Sure.
In fact, the smell of Play-Doh has been trademarked because Play-Doh has a very distinctive smell to it.
Yes, it does.
So, and anybody that smells that knows that's Play-Doh. So it's been trademarked.
So let's talk about perfume for a second. I just had a thought. So perfume, the actual smell could be trademarked, but also then could the formulation to create the perfume then be patented?
Absolutely.
Okay.
Absolutely.
Interesting. And then the look of the bottle have a design patent.
It could have a design patent, and it could also have what's called trade dress, which is kind of like a trademark.
Oh, interesting.
For example, the Coca-Cola bottles have a distinctive shape. The old-fashioned Coca-Cola bottles, those have trade dress protection. It's the look of the bottle.
Okay.
But they could have a design patent, too, if they were very distinctive.
Okay. Yeah,
so you can have several forms of protection on the same thing.
Okay. So with trademarks, are there things that differentiate trademarks as far as one being stronger or than another? What are the type of things that?
Yeah, and a lot of people don't understand that about trademarks. Trademarks have to be distinctive. So when somebody sees the trademark, smells the trademark, hears the trademark, it automatically, in the mind of a consumer, associates that smell, that look, whatever, with the product or the source of that product. So they've got to be distinctive. So somebody comes and they want to trademark something like Apple for apples. This is a very basic example. But if you wanted to trademark Apple for apples, you couldn't do it. Because Apple is generic for apples, so you can't even trademark that.
Sure.
But if you, for example, Apple is trademarked. Apple is trademarked for computers.
Yes.
Okay, well, there's nothing, it's kind of fanciful that you would call a computer an Apple.
Sure, yes.
So that's a very strong trademark.
Gotcha.
Generic, you can't even trademark at all.
Right.
And then there's something called descriptive. If something is merely descriptive, it can't be trademark either. And it could be geographically descriptive even. So, for example, let's say California oranges, California raisins. That's
Okay.
probably a better one since we're so well known
Yes,
for raisins.
we're in the middle
So
of that.
California raisins can't be trademarked, at least initially, because it's merely
Descriptive, yes.
It's raisins that come from California.
Right.
Now, that's not to say you couldn't ever trademark it. Because if you use that over and over and over again for years and years and years,
Right.
and for example, just because Sunkist is a big name in raisins,
Yes.
I'll use them as an example. If Sunkist used that California raisins over and over and over again over a period of at least 5 years, probably more, people might automatically associate that with their raisins.
Right.
And so they might later down the road be able to trademark it.
I understand.
But if it's merely descriptive and consumers wouldn't associate California raisins
Right.
with, for example, Sunkist,
Right.
then you can't trademark it.
Right.
But then you can trademark things that are suggestive.
Okay.
If they're not just descriptive, they might be suggestive. For example, if you had a water gun and called it a soaker, if
Sure.
people get soaked by a water gun, that's kind of suggestive
Right.
of the water gun. But you can trademark that. That's on the stronger end.
Oh, interesting.
And
yeah.
then, like I said, arbitrary, fanciful things like Apple for computers.
Right.
Or, for example, Kodak. I don't think Kodak was an English term at all. It wasn't a word
Right.
prior to Kodak
Sure.
becoming Kodak and
Right.
using that term. So
Yeah.
that's kind of an arbitrary or
Right.
fanciful sort of
Right.
trademark. So the more you get to that arbitrary, fanciful, at least suggestive, but arbitrary, fanciful, the stronger your trademark is going to be.
So, for example, the pie shop, which sort of brings to mind baking and things like that. In our circumstance, it's a product incubator, so that's sort of on the fanciful
Correct.
side. It's not a direct
Correct.
inference; it's indirect. And
Yeah, and I like the fact that you use pi,
Yeah.
P-I,
Yes.
as in the
mathematical
symbol
Yes,
for
yeah.
pi
Yeah.
to indicate,
Sure.
your name for the incubator. So
Yeah, leave it to the
was a
nerd
good
engineer
one.
to do something like that.
Yeah, but that's good. So, and that kind of trademark then won't have a problem with it being merely descriptive.
Right.
Now, if you tried to trademark pie shop for an actual pie shop, that would be a problem.
That would be a
You know,
problem.
a problem that made, PIE, pies.
Yes, yes.
That would be a problem.
Right. So let's talk about registering a trademark. What's involved in that process?
It's much easier than a patent. You file a trademark application. Generally, it's done electronically. And it still takes 6 months to a year, depending on if there's any issues with the application. But you can trademark within six months to a year. And you basically have to submit a picture of the trademark. Now, if it's just words and you're doing, just a standard word mark, you don't really need to submit.
Artwork.
You just artwork, right? But if you're doing a logo, you need to submit the artwork for the logo.
Sure.
Obviously, if you're doing something like a smell, you need to be able to submit to the trademark office
Yes.
the smell.
Right.
Yeah, and that's not going to be done electronically
Right.
generally. Although
Yeah.
I'm hearing that you can do all kinds of things now with 3D
Yes.
printing.
Yes, we can.
But I don't think you can 3D print a smell yet.
We'll work on that. I have a feeling we're getting close. So yeah.
But
Well-
you submit the mark,
Okay.
and then you have to, if there's two different kinds of trademark applications, really, in terms of federal applications. You can file based on, I'm already using the trademark, or you can file on an intent to use basis.
Okay.
An intent to use, you have to have a bona fide intent. You have to genuinely be planning to use this trademark.
Sure.
You can't just file to save it for later. You've got to, be putting together a business plan,
Right.
trying to develop the product, that
Right.
kind of thing. But you can file if you're not using yet. If you're not using yet, you don't have to do much more other than fill out the application, submit the trademark, the logo itself, or whatever it is. But if it's a use-based application, you have to also submit a specimen of use.
Okay.
And-
So if you've actually been using it or going to start using it, you have to show how it's being used.
Right. So you have to
the
show
front of a
the-
package or
Right,
whatever.
exactly,
Yeah.
exactly. You have to show the mark in association with the product or the service.
Gotcha. Okay. And the fees associated with trademarking.
Oh, they're much less. We have a standard fee schedule, and I don't want to necessarily disclose that to the
that's
world
fine, but
right
it's much
here.
less.
But yeah, it's much less. I usually tell people that they can get a trademark registered, actually issued a registered trademark for $2,000 or under. Now, in
Gotcha.
some cases, it could be more,
Sure.
but it could be quite a bit under if there's
Right.
no problems with other marks that are similar
Sure.
and that sort of thing.
Yeah. Okay. All right.
And it takes a much shorter period of time.
Yeah.
too.
Yeah. As I found out when we registered for the pie shop, it didn't take very long at all. It was kind of pleasant compared to the patent applications process I've been through. Painfully long sometimes, but I'm getting older, so I'll get to take advantage of that senior citizen thing here one of these days. So I'll be doing a lot more patenting then. So, anyways, well, I appreciate you coming out here, and
No problem.
and I hope everybody's gotten a little bit more insight on what's involved. I guess the takeaway from this is you got to be careful not to armchair quarterback how you get and what you should do with a patent or a trademark. The best thing you could do is get some advice, get some legal advice or some help from somebody before you start, or ask the questions, And if nothing else, be a little careful. It's better to be careful probably, especially in the beginning. After you get the patent, well, then I guess you're in a lot better shape. There's a lot more things you can do and expose. So I'd like to thank Sherry Flynn, my guest, a wonderful lawyer with Coleman and Horowitz, a regional law firm here that we have a very close association with. And I would suggest you give Sherry a call or any patent attorney a call, I suppose, if you need help. And join us again when on our next podcast. We'll let you know what we're working on, and glad you guys could tune in, and we'll see you soon. Thank you.
Thank you, Mark.